Hello, and welcome to MSBA's program, Just the Facts on Amendment 3. My name is Susan Goldammer, and I'm an attorney with the Missouri School Boards Association. With me today is Kelly Hopkins and Scott Summers, who are also attorneys with MSBA. The official title of Amendment 3 is Constitutional Amendment to Article 9 relating to teacher performance evaluation systems. Our goal today is to provide you basic information about Amendment 3 and how, if it passes, it might impact school district operations. So here's a few facts about Amendment 3. It is an amendment to the Missouri Constitution. The Missouri Constitution can only be amended by a statewide vote. That means changes to the Constitution are more permanent than a state statute because the state legislature can change a state statute from year to year, whereas a constitutional amendment would require another vote of the people to change. Constitutional language trumps statutory language. That means that if there's any conflict between the constitutional amendment and existing state statutes, the Constitution will prevail. Amendment 3, if it's passed, will go into effect on December 4th, 2014, which is 30 days after the election, which is November 4th, 2014. Amendment 3 does not repeal the Teacher Tenure Act, but it does override much of it. And in fact, it does conflict with some statutes relating to administrators and administrator contracts as well. Lawyers will need to read both the new constitutional language and the statutory language together to determine what the law actually is if Amendment 3 is passed. And if there are any gray areas, then a court will need to resolve them. Amendment 3 will not remove tenure from currently tenured teachers because they will still have an indefinite or permanent contract with the district. In fact, many of the changes to the law Amendment 3 makes will not apply to currently tenured teachers. Their evaluations will change, but their contracts will not. Amendment 3 will impact other certificated staff, however, including probationary teachers and those that earn tenure after the effective date of the amendment. Kelly, can you tell us a little bit more about who Amendment 3 applies to?
Amendment 3 applies to all certificated employees of school districts. That includes, of course, teachers, principals, the superintendent, most of the administrators. The definition of certificated under the amendment is anyone who holds a valid license to teach in the state of Missouri, any employee of the school district who holds a valid license to teach. One of the things we don't know about this definition is whether or not someone such as a paraprofessional who holds a teaching certificate but is not currently working as a teacher or administrator in the district would be subject to Amendment 3 as well. That's one of the unresolved questions at this point. Under Amendment 3, certified staff are no longer entitled to a contract. Certified staff are at will unless the district chooses to contract with them. It does not impact contracts entered into before the effective date of the constitutional amendment. So, if a person that we now know as a tenured teacher has an indefinite or permanent contract, that indefinite or permanent contract will stay in force until their separation of employment with the district. In terms of contracts held by others, other than those tenured teachers, that contract will stay into effect until the end of the contract. So if a probationary teacher is in the middle of a one-year contract, that contract will stay into effect until it's time for the contract to be renewed. If you have someone on a 3-year contract, an administrator on a 3-year contract, that contract will stay into effect until it's time to be renewed, and then it would become a district decision as to whether or not to contract. Otherwise, the person would become at will at that point.
Just out of curiosity, Kelly, right now, why do districts contract with teachers and administrators?
Districts contract with teachers and administrators because the law requires them to contract with teachers and administrators.
But that's state statute, not the Constitution.
That is state statute. So the Constitution would trump, as you pointed out earlier, should Amendment 3 pass.
Okay.
Districts can choose to contract with their certificated staff, but they are not required to do so. They can use contracts for up to 3 years, 1, 2, or 3-year contracts, or they can go with no contracts at all. And there's no requirement that employees in a particular group, such as principals, all have multi-year contracts, and teachers all have one-year contracts, etc. The district can choose to contract with each individual employee on a case-by-case basis. You get a contract, you don't get a contract. We do advise school districts, should this come about and should they contemplate giving different length contracts to similarly situated employees, we urge districts to check with their local attorney, because that might have some legal implications if they do that. Okay, Scott, there's more to Amendment 3.
As Susan had indicated earlier, some of the new amendment would override current teacher tenure law. And we're going to talk a little bit about one of those instances right now, and this is how to terminate an employee who, as Kelly was just talking about, is under contract with the district. Currently, there are 6 reasons to terminate a tenured teacher. There are also, under the new amendment, 6 reasons to terminate a tenured teacher, but they're a little bit different than the current rules. So,
and just for clarification, it's not just terminating tenured teacher, it would be any certificated employee that receives a contract. These would be reasons to terminate under the amendment.
Exactly. So the new amendment would allow for termination of an employment contract for physical or mental conditions unfitting him or her to instruct or associate with children, for immoral conduct, for incompetency, inefficiency, or insubordination in the line of duty, for the willful or persistent violation of or failure to obey state laws or regulations, for excessive or unreasonable absence from duty, or for the conviction of a felony or crime involving moral turpitude. Now, the current tenure law allows for termination of a tenured teacher for failure to follow board policy. If you notice, in the new law, that's not there. We think that insubordination under the new law would encompass that failure to follow board policy. However, we're not really sure. Keep in mind that these conditions also apply when demoting, removing, or discharging an employee who is under an employment contract. Assume that the same notice and timeframes for termination for incompetency, inefficiency, or insubordination still apply. The due process issues still apply. And also, we don't know, but perhaps districts might be able to add additional reasons for termination of these employment contracts when they actually contract with these employees under the new law. We don't know yet, but that is a possibility that we're going to look for. Susan, I understand that evaluations play a very important part in this new amendment. Is that correct?
That's correct. In fact, as stated in the title of the amendment, evaluation seems to be a big focus. The district must develop a standards-based performance evaluation system if Amendment 3 passes. And essentially, any school district receiving any state funding or local tax revenue must adopt this evaluation system. But as we all know, every public school district in the state of Missouri receives at least some state or local tax funding, and so this applies to all school districts. Districts must adopt this evaluation system no later than July 1st, 2015, and all evaluation systems used must be approved by the Department of Elementary and Secondary Education. A majority of the evaluation must be based on student performance data. Okay? In fact, the actual language of Amendment 3 uses the term quantifiable student performance data as measured by objective criteria. So it's very specific, and not uncoincidentally, in 2014, the legislature passed House Bill 1490, which was signed into law, that actually defined that exact term as performance on locally developed or locally approved assessments. So this evaluation system must include student performance data, and the student performance data used must be data that is either locally developed or approved presumably by the local school board, which may include statewide assessments, but it may include a lot of other things as well. Please note that anyone who's involved in schools these days knows that the Department of Elementary and Secondary Education has required school districts to incorporate student performance data in their evaluation systems as part of the Missouri School Improvement Program 5. and is also as part of the ESDA waiver, or the No Child Left Behind Act waiver. Only the current evaluation system only requires a significant portion of the evaluation to be based on student data, and ESSE has deferred to school districts to determine what significant means for that particular district. Amendment 3 is a little bit more specific and requires a majority of the evaluation to be based on student performance data, and of course majority means more than half. Districts must not only have evaluations, but use these evaluations when making employment decisions, and Amendment 3 is very specific about this. Evaluations must be used when retaining, promoting, demoting, dismissing, removing, discharging, and setting compensation for certificated employees. It also must be used when modifying or terminating contracts, and in a RIF, or reduction in force situation, where the district's placing certificated staff on a leave of absence because of a decrease in pupil enrollment, or school district reorganization, or a reduction due to a financial condition of the district. The district must use those performance evaluations in that situation as well. So Kelly, one of the questions we have is, will districts still use salary schedules?
Amendment 3 presents potentially a big change in the way districts pay their staff. First of all, as you just pointed out, compensation, the evaluations must be used when making compensation decisions. It doesn't say it has to be the sole reason, but it must be used. Typically, a school district has a salary schedule that has perhaps, the number of years of experience with the district down one side and educational achievements across, and that's how compensation is determined. And it doesn't take into account evaluations. But Amendment 3 would require that evaluations be used. Districts will need to retain salary schedules for those teachers tenured prior to the effective date of the amendment. However, other certificated employees may or may not be paid in accordance with a salary schedule. It may mean that districts use a different type of salary schedule. Perhaps instead of the type of education you have across the top of that salary schedule, perhaps it'll be your evaluation results, so that an employee with 3 years experience who has an excellent evaluation will make more money than an employee with 3 years of experience that doesn't have an excellent evaluation. Districts might want to use a more skeletal type of salary schedule, one that essentially establishes a starting pay so that we know where to put those first-year teachers or people who are transferring in, or any other administrative staff that is subject to a salary schedule. And then from then, we will use the evaluations to set the compensation. So it's pretty wide open.
You mentioned also, just briefly there, it's not just that we have to use evaluations to set compensation for teachers. This also will apply to our administrative and principals.
This applies to principals, this applies to other administrators, again, that meet that definition of certificated employee. They have a certificate of license to teach that's valid in Missouri, so it applies to all of them. And some school districts do have salary schedules that apply to administrative staff. So yes, that would also be impacted. The evaluation will also impact litigation. According to the amendment, if a certified employee is terminated, or any of those ways that an evaluation may be used. I'm not going to go through the whole list. I'm sure there's a list on the slide right now. But anytime they challenge that, they must show that the district did not properly implement its evaluation system. That's one of the burdens of proof that the person challenging the decision has to make. That's a really good reason to look at your evaluation system and make sure that that it's a good evaluation system, and of course that it's consistently applied. Finally, Amendment 3 makes the evaluation system that we've been talking about a management right, which means it's not subject to collective bargaining. What we don't know is whether or not districts that have entered into an agreement through collective bargaining, in which evaluation is part of the agreement, how it will affect those agreements. That's what we don't know.
All right, Scott, How can folks learn more?
Sure. They can go on to the Missouri Secretary of State's website. We encourage viewers and listeners to go on there and look at the entire language of the amendment. Remember that the ballot language will just be a summary, and we encourage that everyone read the entire constitutional amendment language. And you can also contact MSBA's legal department at 1-800-221-6722. We also have our email addresses on the slide, and we'll be happy to help you in any way that we possibly can.
All right. Thank you for joining us today, and please remember to vote on November 4th, 2014.